Chapter 2. Physical Injuries. Article 252. Physical injuries inflicted in a tumultuous affray. Elements. 1. Thereas a tumultuous affray is referred to in the preceding Article 2. A participant or some participants thereof suffers serious physical injuries or physical injuries of a less serious nature. Only 3. The person responsible therefore cannot be identified. 4. All those who appear to have used violence upon the person of the offended party are known. Note: unlike the victim in Article 251, the injured party in the crime of physical injuries inflicted in a tumultuous affray must be one or some of the participants in the affray. Note: penalty is 1 degree lower than that for the physical injury inflicted for those who appear to have used violence upon the person of the offended party. Note: only the one who used violence is liable. Article 262. Mutilation. Definition: the lopping or the clipping off of some part of the body. 2 kinds of mutilation. 1. Intentionally mutilating another by depriving him, either totally or partially, of some essential organ for reproduction. 2. Intentionally making other mutilation, that is, by lopping or clipping off any part of the body of the offended party, other than the essential organ for reproduction, to deprive him of that part of the body. Elements of mutilation of the first kind. 1. There be a castration mutilation of organs necessary for generation. 2. Mutilation is caused purposely and deliberately to deprive the other of some essential organ for reproduction. Note: vasectomy is not mutilation. Note: any other intentional mutilation falls under the second kind of mutilation. Mayhem is other intentional mutilation. Note: penalty of reclusion perpetual when the victim of other intentional mutilation is under 12 years of age. Article 263. Serious physical injuries. The crime of serious physical injuries is committed through 1. Wounding, 2. Beating, or 3. Assaulting, or 4. Administering injurious substance. Note: crime might be committed by reckless imprudence, or by simple imprudence or negligence. Note: there must not be intent to kill. Note: difference between physical injuries and attempted or frustrated homicide. 1. Attempted homicide may be committed even if no physical injuries are inflicted. 2. In the crime of physical injuries, offender has no intent to kill the offended party. In attempted or frustrated homicide, offender has an intent to kill the offended party. Classes of serious physical injuries. 1. Injured person becomes insane, imbecile, impotent, or blind in consequence of the physical injuries. Note: impotence means inability to copulate properly or sterility. Note: penalty when the victim of a serious physical injuries under paragraph 1 is under 12 years of age is reclusion perpetua. Note: blindness under paragraph 1 must be of 2 eyes. Blindness must be complete. Weakness of the vision is not contemplated. Note: under paragraph 2, loss of an eye only 2. Injured person A loses the use of speech or the power to hear or to smell, or loses an eye, a hand, a foot, an arm, or a leg. Or B loses the use of any such member, or C becomes incapacitated for the work in which he was therefore habitually engaged, in consequence of the physical injuries inflicted. Note: it must be loss of power to hear of both ears. If there is loss of power to hear in one ear only, it is serious physical injuries under paragraph 3 of Article 263. Note: loss of use of hand or incapacity for the usual work must be permanent. Note: all those mentioned in paragraph 2 are principal members of the body. 3. Person injured A becomes deformed, or B loses any other member of his body, or C loses the use thereof. or D. becomes ill or incapacitated for the performance of the work in which he was habitually engaged for more than 90 days, in consequence of the physical injuries inflicted. Note: Paragraph 3 covers any member which is not principal member of the body. Note: Deformity is meant physical ugliness, permanent and definite abnormality. It must be conspicuous and visible. Note: Deformity by loss of teeth refers to injury which cannot be repaired by the action of nature. Note: Loss of one tooth which impaired the appearance is deformity. Note: Loss of both outer ears constitute deformity, and loss of the power to hear. Note: Loss of the lobule of the ear is deformity. Note: Loss of index and middle fingers is either deformity or loss of a member, not a principal one, of his body or use of the same. Note: Loss of power to hear of right ear only is loss of use of other part of the body. Note: Illness is a consequence of physical injuries inflicted. There is illness for a certain period of time, when the wound inflicted did not heal within that period. Note: Offended party must have an avocation or work at the time of the injury, in relation to the incapacity referred to in paragraph 3. 4. Injured person becomes ill or incapacitated for labor for more than 30 days but must not be more than 90 days, as a result of the physical injuries inflicted. Note: Paragraph 4 speaks of incapacity for any kind of labor. Note: Injury requiring hospitalization for more than 30 days is a serious physical injuries. Note: Medical attendance is not important in serious physical injuries. Paragraph 4 requires illness or incapacity for labor, not medical attendance. Note: Lessening efficiency due to injury is not incapacity. Note: Qualified serious physical injuries, if the offense is committed against an of the persons enumerated in the article defining the crime of parricide, or with the attendance of any of the circumstances mentioned in the article defining the crime of murder, the law provides higher penalties. Note: Serious physical injuries by excessive chastisement by parents are not qualified. Article 264. Administering injurious substances or beverages. Elements: 1. Offender inflicted upon another any serious physical injury. 2. It was done by knowingly administering to him any injurious substances or beverages or by taking advantage of his weakness of mind or credulity. 3. He had no intent to kill. Note: It is frustrated murder when there is intent to kill. Note: If the accused did not know of the injurious nature of the substances he administered, he is not liable under this article. Note: Administering injurious substance means introducing into the body the substance. Note: Article does not apply when the physical injuries that result are less serious or slight. Note: Weakness of mind or credulity may take place in the case of witchcraft, philters, magnetism, etc. Article 265. Less serious physical injuries. Matters to be noted in the crime of less serious physical injuries. 1. Offended party is incapacitated for labor for 10 days or more, but not more than 30 days, or needs medical attendance for the same period of time. 2. The physical injuries must not be those described in the preceding articles. Note: If the incapacity is more than 30 days or the illness lasts for more than 30 days, it is a serious physical injury. Qualified less serious physical injury. 1. Fine not exceeding 50,000 pesos, in addition to arrest or shall be imposed for less serious physical injuries. 1. A. There is manifest intent to insult or offend the injured person. Or B. There are circumstances adding ignominy to the offense. 2. A higher penalty is imposed when the victim is either A. Offender's parents, ascendants, guardians, curators, or teachers, or B. Persons of rank or persons in authority, provided the crime is not direct assault. Note: medical attendance or incapacity is required in less serious physical injuries. Note: crime is less serious physical injuries even if there was no incapacity, but the medical treatment was for 13 days. Note: it is only slight physical injury when there is no medical attendance or incapacity for labor. Article 266. Slight physical injuries and maltreatment. 3 kinds of slight physical injuries. 1. Incapacitated the offended party for labor from 1 to 9 days, or required medical attendance during the same period. 2. Did not prevent the offended party from engaging in his habitual work or which did not require medical attendance. 3. Ill-treatment of another by deed without causing any injury. Note: some hours after 9 days do not amount to 10 days. Note: when there is no evidence of actual injury, it is only slight physical injuries.